The mission of the Blavatnik School, for those of you who are new to the institution, is to promote teaching, scholarship, and public engagement to improve governments across the world. And I can think of no person who has devoted their lives to that mission more so than Judge Jed Rakoff. So we're absolutely delighted to welcome Judge Rakoff here to the school. Let me start by by providing a few words of introduction to Judge Rakoff, someone whose reputation, for those of us who are in the field of financial regulation, is very widely known. But the judge, of course, as a sitting federal judge for many years, has a wide range, has ruled in a wide range of cases, and has a reputation that goes well beyond that in financial circles. Judge Rakoff graduated in English literature from Swarthmore College and then came here to Oxford in the 1960s as a student at Balliol, where he read Indian history. And thereafter went back to the United States to get his degree in law at the Harvard Law School, and spent about 2 decades in private practice and about 7 years, I believe, as a federal prosecutor in the United States Attorney's Office for the Southern District of New York, which is often known as the Sovereign District of New York because of its wide influence and its originality. And he was nominated to the federal bench by President Bill Clinton, took office March 1st, 1996. And has since developed a reputation as being one of the country's preeminent jurists of financial crimes and matters relating to financial regulation more broadly. So I'll speak a little bit about some of his seminal cases. I think one of the most interesting and recent ones is the case called United States v. Salman, which I suppose is one of the cases you're perhaps most proud of, because it has had a profound impact on defining the notion of insider trading in the United States capital market context. And of course, because of the size of those capital markets, has helped in the definition of insider trading across the world. And Judge Rakoff wrote the decision, ironically not in his own circuit, but in the Ninth Circuit, where he was on a temporary assignment, and that decision has since been affirmed by the Supreme Court. He's also responsible for 2 notable rulings, both involving the SEC. One case was the SEC v. Citigroup, and the other was the SEC v. Bank of America. And in both of these cases, the government had come to an agreement with these banks over questions of their misconduct, particularly over the time of the financial crisis. As the government had settled with the banks, the role of the judge in this particular situation was considered ceremonial and just sort of signing on the dotted line. But Judge Rakoff decided to actually take a serious look at these cases, and as a result, set out a new precedent where judges review the kind of settlements that the government, in particular the SEC, enters into with various defendants. And that has actually set in motion a series of actions that now lead to the government taking these sorts of settlements more seriously. He was also the presiding judge on 2 fairly famous cases, one involving WorldCom and the fraud at WorldCom, and Judge Rakoff was the presiding judge that eventually allowed and oversaw the transformation of WorldCom from a company that had been riddled with fraud and mismanagement to one that was that successfully reemerged from bankruptcy and was subsequently sold to Verizon. So a very successful case of reorganization. And then famously and quite recently was the judge presiding over the trial of Rajat Gupta, the former CEO of McKinsey and board member of Goldman Sachs, who was convicted of insider trading again there. Besides his reputation in the area of financial crimes and white-collar crime, Judge Rakoff is also noted for his work and his writings on the role of evidence in the judiciary, and in particular the intersection of science and the law. And he has actually served on the MacArthur Foundation committee that has looked at the role of neuroscience and advances in neuroscience in helping us appreciate the possibilities and the advances in human understanding and what implications that has for how we think about evidence, particularly eyewitness testimony evidence, and their reliability in legal proceedings. And he's written widely on this area and has also written a textbook on the kind of instructions that judges ought to give to juries as they deliberate on these very complicated matters. This is generally a very international audience, and so beyond his impact in the U.S. Legal setting, Judge Rakoff has served as a trainer for judges across the world, and particularly across the Islamic world, as I looked at the various countries in which you've served as a judicial professor, if you must. So we're delighted with that international role, particularly here at the school. Judge Rakoff is a fellow of the American Academy of Arts and Sciences, and as we were talking on the elevator down here, he actually joins a distinguished list of speakers we've had here at the school who have been banned from Russia. So because of his rulings and his judicial work, and so I suppose you wear that as a badge of pride, and and so I thought I'd mention that as well. We're absolutely delighted to have you here at the school. So Judge Rakoff will speak for about 30 minutes, and then we'll open it up for Q&A. So if you have questions through the course of his remarks, feel free to write them down, and then based on the number of hands that go up, we will take questions, perhaps 2 or 3 at a time. I'll turn it over to you. Thank you so much.
Thank you so much. So I want to thank Karthik for that extremely nice introduction. It's probably the longest introduction I've ever had, and I was sorry that it had to end. And I'm also very grateful that my wife is not here because she would demand rebuttal time. It's so nice to be back in Oxford. Of course, I'm very disappointed, like all Americans who went to Oxford. I thought it should stay exactly the same for 900 years. And then we have this fantastic new building. What a break with tradition, but it's really a lovely building, and so nice to be here. I do have to, however, at the outset, let you know that under U.S. federal law, I am prohibited from commenting on any case now pending in the courts, not just my own cases, but any case anywhere in the world. And I'm also prohibited from discussing any issue that's likely to come before me for decision in the immediate future. So that concludes my speech. Thank you very much. I think one of the things I am free to talk about is what any school child in the United States learns in the first few years of school, which is that the American Constitution creates 3 branches of government, and each serves as a check and balance on the other branches. And I want to suggest that that doesn't really operate in terms of the judiciary's ability to check the executive. Now, I raise this issue because there are cases pending now, which I won't discuss, including some lower court cases that do seem to challenge the ability of the current executive to take various steps. But the news I want to bring, which may be disappointing to many of you, is that the judiciary has a long, and in my view, an unfortunate tradition in the United States of being much more a check on the legislature than on the executive. This traces all the way back to what is probably the most famous Supreme Court case in the entire history of the United States, which is Marbury versus Madison, decided in 1803. And that case is usually trotted out as an example of the Supreme Court asserting its power to review the legislation to see if it accords with our written Constitution and to hold it unconstitutional if it does not. But if you look at that case a little more carefully, it becomes a little more complicated. The facts of that case were this. During the presidency of John Adams, the second president of the United States, political parties had developed for the first time. And on the one side, there were the so-called Federalists, of which John Adams was an example. These were primarily merchants from New England. And on the other hand, there was what went by the sort of awkward name of Democrat-Republicans, which was the Jeffersonian Party. And on the one hand, that party was very much in favor of increased democracy and greater participation. On the other hand, it was largely led by Southern slaveholders. So those two parties began to clash. And in the presidential election of November 1800, Jefferson was elected. And the Federalists and John Adams then realized that if they were going to be able to have any impact over the next few years, they had to take control of the judiciary. This is a strategy that we can see right up to the present, but it traces back right to the beginning. And so Adams nominated, and the Federalist-dominated Congress confirmed a bunch of judges, and they were called the Midnight Judges because Adams was literally still signing their confirmations up to the very last day that he was in office. And the Federalists were also concerned that maybe, even though these judges, who, as all federal judges in the United States have lifetime tenure, might be seen by the Democrat-Republicans as questionable, that they would pass legislation which would force the executive, and specifically the Secretary of State, to issue the commissions that would allow these newly confirmed judges to take office. So Jefferson becomes president. The Secretary of State is James Madison, who later became president, and who was the primary author of the United States Constitution. Madison refuses to sign some of the commissions. He eventually was talked into signing a few of them, but he didn't sign them all, including he didn't sign the commission of a rather low-level judge, a judge named William Marbury. So Marbury sues, and the case goes up to the Supreme Court of the United States. And the Supreme Court of the United States, through its great Chief Justice John Marshall, first announces that under the Constitution, it is the Supreme Court which has the final say as to what the law is. And we have determined that this law passed by the Congress, the Federalist Congress in its waning days, that said that we must issue commissions to these new judges, was beyond the Constitution. It's unconstitutional. That's what the case is normally cited for. It was the first case in which the Supreme Court held a statute unconstitutional. But notice what was the effect. The effect was that the court then went on to say, so even though Madison should have issued these commissions, and he had no right not to issue those commissions, we have no power to force Madison to issue these commissions. So if you look at it from the standpoint of the Supreme Court's review of executive action, it was a cop-out. Now, most historians say that Marshall did it that way as a kind of compromise. He wanted to assert the power of judicial review, and yet he didn't want to have a total battle with Jefferson over what was a fairly minor judge. Maybe, but it was really a portent of things to come. And over the next 200 years, the Supreme Court has developed a whole long laundry list of doctrines that prevent the court from reviewing executive action. These are totally judge-made limitations. You won't find them anywhere in the Constitution, and yet they impose tremendous burdens on any attempt by the federal courts to review executive action. I'm just going to mention 9. Now, that sounds like a lot. Let me assure you I could go on to 15 or 20 of these doctrines. The first one, the one that perhaps makes the most intuitive sense, is that the Supreme Court will not review the president's exercise of his war powers. But the Supreme Court has carried this to inordinate extremes. The most extreme case, perhaps, and certainly the most outrageous, was the Korematsu decision in 1944. So in 1941, after Pearl Harbor, a lower-level general in the Pentagon said, you know what, we can't trust those Japanese Americans. We better put them all in concentration camps, in internment camps. Concentration camps are just for the Nazis. In the United States, we'll call them internment camps. And this was about 100,000 Japanese Americans, of whom 60,000 were full American citizens. And they were all rounded up, mostly in California, and put in these internment camps. And they challenged this, of course, and it wended its way through the court, and it finally got to the Supreme Court of the United States in 1944. And the Supreme Court, in a 6-3 decision written by Justice Hugo Black, who is generally regarded as one of the most liberal, libertarian justices ever, affirmed the internment of the Japanese Americans on the ground, and not that it was right, not that it didn't violate the 14th Amendment, not that it didn't deprive these Japanese Americans of anything like due process, but because the court had no power to review an act taken by the president in furtherance of his war powers. So you can see how absurdly broad the court has interpreted the war powers doctrine. Now, the related doctrine that the court has often invoked is the so-called national security doctrine. For example, after there was the expose of torture at Guantanamo, which, by the way, was never ruled unconstitutional by the courts, but was overturned by Congress to its credit, the CIA began sending certain of the Guantanamo prisoners that they thought might be have helpful things to say to countries that did practice torture. The theory being they would be tortured there and would tell what they had to tell. This, of course, begs the question of whether torture really ever gets people to tell the truth or just gets them to tell what they think will please the people who are torturing them. But putting that aside, this was challenged, this rendition to countries that were known to practice torture was challenged in the courts of the United States. And the courts said, oh no, we can't hear that because that involves state secrets under the national security doctrine, and we don't touch that. So that is another doctrine that the courts have invoked. A third doctrine that they've invoked, not quite as broadly as the first two, but quite commonly, is the foreign affairs doctrine. The president has total authority over foreign affairs. We in the courts won't take a look at it. I had a case in my own court some years ago involving this. The numerous countries which have missions to the United Nations in New York will buy entire buildings. One country, forgive me, Karthik, India, purchased a 26-story building, and they used about 6 of the stories for their business as a mission to the UN, and they rented out the rest and made a lot of money. And believe me, in New York with the rents, you can make a lot of money. And the city of New York then sued them for taxes, for real estate taxes. And I upheld that complaint and ordered that they pay the taxes. The case went up to the Court of Appeals. And while it was in the Court of Appeals, the State Department issued a notice which said that all countries that have missions to the UN in New York cannot be taxed in any way, shape, or form because it would interfere with the government's free conduct of its foreign affairs. Well, of course, that'll cover anything, and apparently it did cover this. The Second Circuit Court of Appeals said, much as we might otherwise agree with the position of the city of New York, we have to defer to the State Department. They say it's going to interfere with foreign affairs. That's the end of the question, and they reversed my opinion. But I've forgiven them. Another doctrine, one of the most commonly invoked, but also one of the vaguest, is the so-called political question doctrine. This is the notion that if a case really involves something that is more the kind of policy that is decided by the legislature than by the courts, then the courts shouldn't touch it. Where this is controversial right now is in the area of political gerrymandering. For those of you who aren't familiar with the American term gerrymandering, that means that you design a congressional district in such a funny way that it makes no geographic sense, but it's designed to allow the party in power to win that election by, you take an area that has 60% of voters of one party, and then you add to it another section over maybe 100 miles away that is also very favorable to that party, and you put together this very awkward district. Again, this goes back in American history forever. It's called gerrymandering because Elbridge Gerry, who was the first person to do this, did it as governor of Massachusetts in about 1805. So the Supreme Court has held that if the gerrymandering has a racially invidious effect, they will look at it under the 14th Amendment, but otherwise it's a political question and therefore not for them to look at. About 2 weeks ago, a lower court in North Carolina, federal court, held for the first time that politically gerrymandering in North Carolina was unconstitutional. Just yesterday, the Supreme Court of the United States stayed that decision. Now, I can't predict, or even if I could, I won't predict because I'm not allowed to, how that case is going to come out. But I will tell you historically, the courts have not touched that stuff under this political question doctrine. Then another doctrine, also quite vague, is the doctrine of standing. None of these doctrines are in the Constitution. This is all judge-made law. The doctrine of standing says that if you want to sue the government for what you consider a unlawful action by the executive, or for that matter by the legislature, but it's usually by the executive, you have to have suffered a personal injury that is unique to you. It can't be an injury that everyone affected by this executive action has suffered, because then it's a political question. So it has to be unique to you. That's like a catch-22. It's really hard to satisfy that. So an example of that is a case from 1975 called Worth v. Selden, a Supreme Court case. So a lot of people in the city of Rochester, New York, wanted to move to a very nice suburb, and the zoning board of that suburb made a practice of denying anyone moving into that who was not rich. I'm simplifying this a little bit, but basically they kept out anyone of middle class or lower class income through their interpretation of the zoning laws. This was challenged as contrary to the equal protection of the laws guaranteed by the 14th Amendment of the United States. Supreme Court said, we're not going to hear this case because this affected everyone equally. It's a political question. Your remedy is to throw out the zoning board. Yeah, right. Sure, if any one person had suffered a particularly onerous injury different from everyone else, then you would have standing. Otherwise, you don't have standing. Now, still another doctrine that keeps a lot of cases out is sovereign immunity. This is derived from English common law. The notion is that the king cannot be sued. Now, I had thought, forgive me, I must have this wrong, that in the United States we fought a revolution because we didn't think the king was always right. But I must be mistaken because in the United States, the government still has sovereign immunity. You cannot sue the United States. You cannot sue any officer of the United States. They all have absolute immunity. The judges also have absolute immunity. That, of course, is fine. But and even local police have what's called qualified immunity, which means they can't be sued unless what they did is totally irrational and off the charts. Still, another doctrine, and this is one that Congress came up with, and during the Clinton administration, yes, I was nominated by President Clinton, but I'm ashamed that he introduced this particular legislation. It's called AEDPA, which stands for Anti-Terrorism and Effective Death Penalty Act. It's called that because it had nothing to do with anti-terrorism and very little to do with the Death Penalty Act, but it really sounded politically great. But it's usually referred to by its acronym AEDPA. AEDPA says that a federal court cannot consider a habeas petition, that is, a petition by a state prisoner who says, I'm being held unconstitutionally by the state, I want federal review, that the federal courts cannot review that unless the decision of the state court that imprisoned this individual was contrary to, quote, clearly established federal law. Well, of course, all the great decisions under habeas have involved new questions, not clearly established. A great many of the Warren Court decisions that we are all so proud of, for example, Guinean, which is the decision that says everyone has a right to counsel, even if they can't afford one, were habeas cases out of the states. If AEDPA had been in effect during the Warren Court years, none of those decisions would ever reach the court. And as it is, habeas has become a hollow remedy for most purposes as a result of the AEDPA exception. Another example, which is sometimes invoked, sometimes not, is that you need to be a citizen to have standing. Now, not for all purposes, and aliens do have the right to sue for certain purposes, but To give you an example, in a case called Shaughnessy, Mr. Shaughnessy was a lawful U.S. resident, but not a citizen. He made the mistake of traveling abroad because his name was Shaughnessy. He, of course, went to Ireland. And he comes back, and he's grabbed and detained in the belief that he was part of the Irish then Republic Army, quote, terrorist movement. And he is being held there indefinitely at the border. And he tries to get into court, and the court says, hey, you're not a citizen. We're not going to hear you. And the final example, and as I say, I could give a lot more, but just one final example is the so-called Chevron doctrine. The administrative agencies in the United States, which are technically a part of the executive, although they exercise both executive, legislative, and judicial powers, have, among other things, the first shot at interpreting various federal statutes that fall within their areas of expertise. The Chevron doctrine, which was promulgated by the Supreme Court about 30 years ago, says that if the way the administrative agency interprets the congressional law is reasonable, even if it's not the preferred interpretation, even if it's not the interpretation that we, the courts, would give it, it will become the law of the land. We will defer to the administrative expertise. Now, see how totally this has turned Marbury v. Madison on its head. Instead of saying, as Chief Justice Marshall so famously said in Marbury v. Madison, it's up to the courts to determine what the law means. Now, under Chevron, we're saying it's up to the executive in the form of an administrative agency to determine what many laws mean, and unless it's totally crazy, that will become the law of the land. So, my point, it's a discouraging one, it's an unfortunate one, but I think you need to know it, is that the courts have developed many, many, many ways to duck reviewing the actions of the American executive. Now, you might ask, why have they done that? So, I think there may be 3 or 4 reasons that I would offer. This is somewhat speculative. The one that's given by the court itself is this is in fulfillment of separation of powers. The great proponent of this view is the late Justice Scalia. And he famously said, it's the role of the court to mind its own business. Well, of course, that is a totally circular argument. The question is, what is the business of the courts? According to the Constitution, the business of the court is to determine what the law is and tell both the executive and the legislature when they have violated the law. But that was not Justice Scalia's view. I think a view that is probably closer to the truth is there is a long body of both judicial and academic literature that say that because federal judges in the United States are not democratically elected and because they hold their position for life, they have to remain, quote, above the fray. They shouldn't enter into much into controversial areas. The Warren Court, of course, was a great exception to this, but then the people who support this approach say yes, and that's why you used to see billboards saying impeach Earl Warren. But I would like to suggest to you that there's no way the court can avoid controversy. If the court had decided Roe v. Wade, the case that said there's a constitutional right to abortion, the other way, it would have been equally controversial. And you'd be still having huge fights about it. And simply saying it's not our business doesn't take away from what every citizen understands is, if you're not deciding it, you are deciding it because you're saying the status quo stands. as it is, despite whatever legal objections there might be to the status quo. So I think this is not ultimately a very satisfactory rationale, though I think it is one that a number of judges buy into. I want to suggest that another reason judges may take this approach is the fact that they realize deep in their heart that they are dependent on the executive for enforcement of their rulings. In that sense, the courts are the weakest branch of government. There's a famous saying attributed to Andrew Jackson when the Supreme Court of the United States, again under Marshall, Chief Justice Marshall, decided one of its very few cases favorable to the American Indians. Jackson, who was not only president but had a long history of being a famous fighter, Indian fighter, said, Chief Justice Marshall has made his decision, now let him enforce it. And in fact, Jackson never did enforce that decision. That decision would have prevented, for example, Indians being forced into reservations, often through arduous treks for hundreds of miles. All of that happened because, among other things, Jackson refused to enforce the decision of the United States Supreme Court. A more recent example that could have been a disaster, thank God was not, came after Brown v. Board of Education, probably the most famous Supreme Court case of the last 100 years. That's the case that said that schools must be integrated, racially integrated. After that decision came down, the governors of most of the southern states said, we're not going to abide by it. We're not going to force it. They even dredged up doctrines that had not been heard of since before the time of the Constitution about that the power to interpret the law of the land rests in the sovereign states, not in the federal government, and so forth. And one of the major proponents of this was Governor Faubus of Arkansas, who actually sent out police to prevent the integration of schools in Little Rock, Arkansas. So the matter then came before Dwight Eisenhower, President Eisenhower. Eisenhower actually hemmed and hawed. He was worried that the country was breaking apart over this issue. He feared that the same forces that had led to the Civil War were still very potent, and I think that's probably true and still potent to this day, unfortunately. But his Attorney General, a very great man named Herbert Brownell, finally convinced him to send in the troops to Little Rock, Arkansas, to, by force, enforce integration of the Little Rock schools. And there's a very famous photograph that some people possibly may remember of little, 7-year-old black children being led into a public school by seriously armed federal militia, because that's what it took. But if it hadn't been done, Brown v. Board of Education would have been a nullity too. And I think a lot of judges deep in their hearts worry about, we need to stay to some degree on the positive side of the executive, because ultimately the executive is what we have to turn to enforce our laws. A final factor I'll mention is sort of built into the Anglo-American system of justice, which is stare decisis, the heavy reliance on precedent. Because under the Anglo-American system of justice, judges make so much of the law. It's not like in so-called civil law, European countries, where you have a code, and although the differences can sometimes be exaggerated, nevertheless, the fact remains that a great deal of the law in Great Britain, the United States, and all former British colonies is made by judges in one sense or another, and therefore there's a need for certainty, and the need for certainty is supplied by the doctrine of precedent, stare decisis, we will stick by precedent except in the most extreme cases. This has an automatic conservatizing effect on most judiciaries, and certainly that's been true in the United States. I think it's a fair statement that with the exception of the Warren Court years, which no one expected, that the Supreme Court of the United States has been a conservative institution through most of its existence. But part of that, what part of goes with that is this leave the executive alone. That's not our bailiwick. Now, I don't want to leave you with the notion that this is all inevitable. Judge-made doctrines can be unmade by judges. And there have been cases in relatively recent history where the Supreme Court has gone the other way. Three come to mind. The first, chronologically, was when President Truman seized the steel mills of the United States during a big strike in 1950. And he gave as his rationale that we were fighting the Korean War and steel was necessary to supply our troops in the Korean War. So this was being done pursuant to his war powers. Supreme Court said, oh, come on, give me a break. We know from everything you said that you're intervening here because you don't like this strike and you want to bring it to an end. And so they reversed that decision. A second case came during Watergate. So it turned out that Nixon had recorded all the conversations in the Oval Office. By the way, I don't know if you know this, so did Kennedy and Johnson. It was not Nixon who began this, but in any event, in Nixon's case, of course, it was very important because it showed what a crook he was. So once it came out that he had these tapes, both Congress and the Department of Justice subpoenaed the tapes, and he resisted on the grounds of presidential privilege, which was itself a reasonably well-established doctrine. And the Supreme Court said, nope, you have to turn over the tapes. Why did they do that? I think a fair reading of it is because they knew Nixon was going down, and they figured better be with the winners rather than the losers. The third case is much more recent. It was, if I remember correctly, in 2007 or 8. It's a case called Boumediene. Really fascinating case. In Boumediene, prisoners in Guantanamo brought habeas corpus petitions. And the matter came before the Supreme Court. And the government said, habeas doesn't apply here because even though it's not the state, so AEDPA isn't involved, these, number one, they're not citizens, so that exception applies. Number two, in our view, they are prisoners of war. Therefore, the war powers doctrine exception applies. Number three, we don't think Guantanamo is really part of the United States, so the foreign affairs doctrine applies. They went on and on in invoking so many of these doctrines I've just talked about. The Supreme Court, a fairly conservative Supreme Court, said, no, you're wrong. We think habeas will lie. And that was a terrific decision, but it's never been followed up. Subsequent to that decision, a whole bunch of habeas petitions were brought by Guantanamo prisoners, and every single one of them has been denied on one ground or another. Usually by the D.C. Circuit Court, they haven't really gotten up mostly to the Supreme Court. So it was an important decision, but at the same time, a little bit of a hollow reed. So where do I come out on this? First, Cassandra-like, I think I am obligated to tell you that there are many, many, many judicial impediments to the courts exercising any meaningful control over executive excess. Second, none of this comes from the Constitution. It all comes out of the courts themselves. Thirdly, there's nothing inevitable about it. And fourthly, in my humble personal opinion, it would be a great tragedy if this continued and if the courts failed to exercise meaningful control over genuine executive excess. Be happy to take any questions. Thank you so much.
Thank you. So we'll take questions in a moment, and if you do have a question, do raise your hand and wait for the microphone. Wait for me to call on you, and then the microphone comes to you. It's important we speak in the microphone because this event is live streamed as well, and the people who are viewing this remotely do need the microphone to hear the questions. Okay, so we'll open up for questions in a moment. While you're preparing your questions, let me ask you the first question, Jed.
Oh, no, you're not allowed.
Which is, since we're in the United Kingdom, I thought let's try apply some of what you said to the context here. And the United Kingdom has experienced, like the United States, sort of a profound shock to its system over the course of the last year or so. And some have argued that through the absence of a constitution, a written constitution in an event, the country has sort of inadvertently stripped itself of citizenship of the European Union, not through some grand design, but again through sort of an inadvertent process. As you think about the constitutional remedies in the United States, and both the UK and the US have served as sort of net exporters of practices of governance over the last 100 or so years, are there any lessons from the U.S. constitutional experience that might apply here in the context of the UK, particularly in the situation with Brexit?
So I'm not really well equipped to answer that question in any specific fashion because I don't have a really pinpoint knowledge of how the UK judiciary operates, and second of all, because I'm an unabashed Anglophile, so anything you guys do is fine with me. But I will say the one place where a written constitution has stood the United States in very good stead is in freedom of speech. We probably have the greatest freedom of speech of virtually any country. And it has our First Amendment guarantee of freedom of speech has been interpreted to allow very robust criticism of government officials and other public figures. In my understanding, I hope I don't have this wrong, is that in the UK, without that kind of written guarantee, defamation lawsuits are a real threat and are often broad, and the result is that the media is less ready to criticize in the sort of very robust fashion that many American newspapers and other media do, government officials and other public figures. In the United States, because of the First Amendment and the way it's been interpreted, you can say almost anything you want about a public figure, and you can't be sued for defamation unless you had, quote, actual malice, which is a very difficult standard to reach. Now, the bad side of that is lots of false things are said about public figures, but in my view, more than compensating upside is that we have an incredibly robust debate on virtually any public issue whatsoever, and all points of view come out without anyone fearing that they might get sued. And ultimately, that does trace back to our First Amendment. So I offer that just with a lot of qualifications as at least one advantage of a written constitution.
Okay, fantastic. So we've got the first question over there in the back. Right here, third row in. Sorry. And if you can keep your hand up when I call on you, just so that the people with the mic can find you as well.
I want to talk about young.
Could you just introduce yourself in one word, your name and who you are?
My name is Jeff Rennes. I'm a retired professor from the University of Montana School of Law.
Fantastic.
And your beard is almost as good as mine.
Yes, I appreciated that you wore yours today. I want to talk about Youngstown in a second, but first I want to mention something about Daniel Marbury's case, and that is that, in fact, the Secretary of State under Adams had signed Marbury's commission. And so Marbury had checked every single box that entitled him to take office. And what had happened is that Madison refused to deliver it, to hand it to him.
That's right. Thank you very much.
Yeah,
Exactly. It was sitting in his
Sitting in his box, his outbox.
That's exactly true.
But the most remarkable thing about that is that the Secretary of State who had signed Marbury's commission was John Marshall, who wrote the decision that said he can't receive the commission.
Well, the conflicts, of course, were such that today they would not be tolerated. Marshall was a cousin of Jefferson, a cousin of Madison. There were all sorts of things like that. The underlying cases, you point out, involved the very people who were judging the case. But that, in those days, that kind of thing was winked at. So, but you were absolutely right.
We're small and new.
So in the interest of the wider audience, well, let's just take the question and then we'll come.
Yes.
Yeah.
So anyway, back to Youngstown. As I remember in Youngstown, one of the things that was sort of the court worried about was whether Truman would obey the order. And in fact, he did. And that touches upon your comment about how weak the judiciary is in that sense. And I wonder what would happen today with what we see as an erratic chief executive in the office. If you can speak to that, I don't know if you can.
I can't speak to that. I'm forbidden to. Youngstown v. Ohio is the case involving the steel seizure under Truman. And as was correctly stated, there was a question there, just as there had been with Andrew Jackson. Would the president actually enforce this? Truman, who I think was in many ways a great president, but he was a very strong-willed president, and there was some feeling that he wouldn't go along with it, but he did. The judiciary correctly, in my view, is prohibited by law from commenting on anything regarding the current chief executive, so you'll have to form your own opinions.
Okay, we have a question all the way in the back there, Kelly. Thank you. So just your name and who you are, and then the question.
Hi, I'm Danny. I'm a DPhil student in politics at New College. This goes both to your talk and also your experience training judges throughout the world. So two judges you mentioned, Hugo Black and Earl Warren, have the distinction also of being former politicians. They were not career jurists. And there have been several other famous judges in American history and all over the world who are not career jurists. I was wondering if you could offer some comment on the suitability of politicians as jurists, and if that makes any difference in their ability or their willingness to check political branches of government.
So let's hold that question and take a couple more, and then we'll come back to you. Okay, so we've got a question right up front here.
You're assuming I can remember that.
I'm writing them down, don't worry. Yeah.
Mohammed Mursi, I'm retired now. A couple of thoughts.
I can hear you, but I think you maybe need to speak louder.
Yes, Mohammed Mursi. Just a couple of thoughts, one relating to the present and one possibly for the future. The question for the present is, one of the doctrines which you alluded to in your very last remarks was the notion of executive privilege. At what point in time does that start to apply? And does it apply when you are technically not in office, but you are sort of electing to be in office? And the future question is this: do you ever contemplate seeing a situation where robots will take over the function of judges? And in that sort of situation, clearly they will be the best to uphold precedent because it's very easy. They've got data points that can allow them to know what the law was, what the law has been. And then how do you how can you ever program one of these to actually develop the law? Do you think we will ever see that, or not in our lifetimes?
So I hope Karthik wrote down all 5 questions.
And then we had a question right next door. Yeah.
John Huffmeyer. I'm with the Center for Mutual and Employee-Owned Business here at Oxford University. In the vaguest possible way, will you help us understand more about money laundering?
More about what?
Money laundering.
Oh, money laundering. Oh,
Okay.
Sure.
Okay, so let's stop there, and we've got a number of questions. We've got perhaps do career politicians make better judges? That might be one place to start, and then we'll take it from there.
So all judges in the federal system have some sort of political connection. That's how you get nominated as a judge. I had relatively little, but I had some, and there are some who are thoroughgoing politicians and been elected to office. I have not seen any material difference in who turns out to be a great judge and who turns out not to be a great judge. There is this difference now insofar as the Supreme Court goes. It used to be that the president would appoint to the Supreme Court many people who had never been judges before. Now they get tested by being a federal judge in the Court of Appeals for at least a few years, and that's true of all 9 current judges. And that's because the politicians don't want to have another Earl Warren. So Earl Warren was the governor of California during Japanese internment, and for political reasons, he supported it. He gets appointed to the Supreme Court, and lo and behold, he turns out to be one of them, not only one of the greatest, but one of the most liberal justices ever appointed. Go figure. So the theory now of both Democratic and Republican senators is, let's let a guy be a federal judge for at least 2 or 3 years, so we'll know how he's going to decide controversial cases, and also because then he'll be locked in his own prior decisions, so we'll know what we're getting. Whether that's a good or bad thing, there it is. But I don't think the mere fact of being a formerly elected politician means that much. The last member of the Supreme Court who was a elected politician was Sandra Day O'Connor. She was sort of down the middle, so I don't think it particularly affected how she ruled.
Okay, we have a question on whether advances in artificial intelligence in particular might supplant the role of humans in the judiciary.
So I'm sure they do a much better job. I want to address that really by avoiding it and talking about a related issue, which is the role of science in the law, which is something I have spent some time on. The science increasingly permeates every aspect of the law. It's not just like patent cases, which are on their face sort of scientific, but forensic science in criminal cases, the computer science in copyright cases, medical science and toxic tort cases. I could go on and on. You can't avoid it. Who is your average judge? It's a person who became a lawyer because they didn't want to be a scientist. I mean, they took that one in America, the one required course that you have to take, usually geology or astronomy. They got their gentleman's B, forgive me, and that was it. Now they have to deal with science, and that's a serious problem. The good news is that most trial lawyers, and virtually all federal judges were trial lawyers for a decade or two before, are quick studies. That's part of what it means to be an effective trial lawyer. And so once they force themselves to get into the science, they actually usually are pretty good in understanding it. So there's an initial hurdle that has to be overcome. I'm sure that will be true with artificial intelligence as well. We have in the United States something called the Federal Judicial Center, which is the educational arm of the judiciary, and they do a pretty good job of at least letting judges know this issue, neuroscience, for example, is coming up. You're not going to be able to avoid it. It may not be in your court today, but it'll be in your court in the next 10 years. So here's a basic primer to get you started, a short pamphlet, and take a look at it, or at least keep it on your bookshelf for when that case does come up.
Okay. So we have a couple more questions, but let's see if we can get to those in time. But there was a hand up right there in the back. Yeah. Thank you, Anne.
My name is Joshua Gensler, Oxford Law Faculty. I would love to talk to you about some of your brilliant writing and judging on death penalty and on settlement of financial cases where Goldman Sachs or whoever gets to admit no fault, pay a lot of money quietly, and keep marching on making profits. But I suspect that that might fall within your prohibition. So I wonder if I could ask you about executive review. Worcester in Georgia was the case where the President of the United States flouted a martial Supreme Court command leading to the Trail of Tears and the eviction of the Cherokee Nation. Is that case still regarded as a precedent or an excrescence?
Okay. Other questions? Yep.
I'm sorry, I didn't know when you wanted me to start.
No,
because there was a question here.
Yeah, no, and we'll get to those. Yeah, but we've got. Yep. Go ahead.
Thank you. Mason, an NPP student here at the Blavatnik School. My question is more about the role of public opinion in determining whether cases get taken up. What is the calculus that public opinion plays in whether or not a case is ruled upon or passed upon?
Okay, and we can take one more question, all the way in the back.
Thank you, His Excellency. So that was really fascinating. You are talking about the judiciary as a check on executive power and uncertain future. So you think this is the issue to the common law system or the for the written legal systems as well, like German or the other countries? Thank you.
Okay, and just say one word about who you are as well, just so that the judge.
Yeah, I'm sorry. So I'm an MPP student at Blavatnik.
Okay, fantastic. Let's the role of public opinion in taking on cases. How about that?
Yeah. So let's start with that. So, in theory, public opinion should have nothing to do with judging in the American legal system. That's why federal judges are given lifetime tenure because they are supposed to be able to withstand public opinion and make independent judgments no matter who it offends. Some judges are better at doing that than others, is the reality. My own view is that the Founding Fathers contemplated that federal judges would be particularly sensitive to the rights of unpopular causes, unpopular litigants, minorities that could never hope to affect the legislature and things like that. And so that independence should be exercised always, but particularly in cases involving those situations. So the track record is mixed. Some people think that the worst Supreme Court decision ever was the Dred Scott decision before the Civil War, which essentially held that African Americans are property, not human beings. Chief Justice Taney, who wrote that decision, thought that he was solving the great conflict of public opinion by finally definitively resolving it, albeit in what you and I would consider an absurd way. Of course, it was just the opposite. It just provoked tremendous outrage that helped lead to the Civil War. It's another example of what I mentioned earlier, which is there's no way for the court not to be controversial. They can't avoid it. I think the best judges try to consciously insulate themselves from public opinion. I will give one tiny example that will have probably very little meaning to the folks here, but what the hell. So one of the first decisions, the New York has a basketball team called the Knicks. They were in the playoffs, which is very important. In 1996, I was a brand new judge. And during the playoffs, they were ahead by 3-0 in a best-of-7 series. And then 6 of their members were suspended from the team because they got in a brawl, which is you're not allowed to do. So they appealed to the courts, and it came to be my case. And before the case came to me, my law clerk said, my husband says that if that case comes to us and you don't decide in favor of the Knicks, I can't come home tonight. So anyway, I decided it in favor of the commissioner and against the Knicks. And I called up my wife and I said, I've had this interesting case. She said, I know all about it. And your daughters say you shouldn't come home tonight. So that's public opinion.
Okay. So we have a couple of questions around your portfolio of cases on financial crimes, and let's see if we can take those together. There was a question on money laundering, and there was a question on your review of administrative settlements, the SEC v. Citigroup or the SEC v. Bank of America type cases. Do you want to comment on that in that area in general?
Sure.
Yeah.
So first on money laundering. Money laundering is a fairly simple concept. It is taking the proceeds of a crime and trying to disguise them through transfers that will make them appear to be the proceeds not of crime. I have no problem at all with the basic concept of money laundering. It arose originally in an attempt to cut out the economic incentives to drug dealing on an international basis. Money laundering has had 2 areas that are controversial. One is that it frequently represents the extension of U.S. prosecution to foreign figures, and that raises all sorts of difficult questions about extraterritorial application of U.S. law, which on the whole has been narrowing, but in that area has been expanding. So that's one problem. The other problem is it carries very heavy penalties, so prosecutors use it as a weapon to coerce guilty pleas from people who might not otherwise plead guilty. They say you're charged with a 5-year count of X and a 20-year count of money laundering. And if they took the proceeds of their alleged crime and it all did anything with it, put it in a bank, they could be charged with money laundering. So it becomes, it's in the wrong hands, a coercive weapon that it wasn't designed to be. So that really, I think, all I want to say about money laundering. In terms of financial crimes, my view, which I've expressed in many opinions, is that the criminal law is basically applied moral law, and that if people have committed crimes at whatever level, those people should be brought to justice. I've been very critical of the Department of Justice, both under the Obama administration. It hasn't come up as much in the current administration yet, I don't know, for not prosecuting high-level executives in connection with the aftermath of the financial crisis. The view of every government body that looked into the reasons for the financial crisis came to the conclusion that fraud played a significant role. It wasn't the only factor. Government action was part of the problem too, but nevertheless, fraud was definitely present. Mortgage-backed securities that everyone who was selling them knew were a very low level were being portrayed as acceptable level, and the people who so portrayed it knew for sure that that wasn't the truth. And that seemingly was so widespread that it's hard to believe that it didn't rise, that practice did not rise to fairly high levels. Instead, the government chose to go after banks as entities rather than after the individuals. I think that was a terrible mistake on a variety of levels. First, it means that the people who actually committed the crime aren't prosecuted, especially the high-level people get off because it's harder to make a case against the high-level people. So rather than doing the work, you take, under U.S. federal law, the crimes of even low-level people can be imputed to the entire corporation. So it's easy to make the prosecution against the company, much harder to make it against the high-level people. The way you do it against high-level people is by flipping people. Same as in mob cases, same as in drug cases. You start with a lower level and you flip them and get higher level. But it takes 2-3 years. I was chief of the fraud unit prosecutions in the U.S. Attorney's Office in the 1970s, and we never prosecuted a company. We considered it a failure if we didn't find the highest level person who actually committed the crime. Now, not all high-level people commit the crimes. I don't want to be misunderstood. But there are many cases where they did, and that was in Enron, and that was in WorldCom, and that was in the S&L crisis. And we prosecuted all the top CEOs and convicted them in those cases because they were guilty. If you go after a company instead, it's easy. The government justifies it because it saves resources. But the effect is not only that the people who committed the crime and who orchestrated it in some cases get off, but you punish a lot of innocent people. So when you go after a company, it pays a great big fine. The government announces today J.P. Morgan paid $3 billion. Isn't that great? Well, that money is coming out of the pockets of shareholders who had absolutely nothing to do with the crime. It's also indirectly coming out of the pockets of employees, because if the fine is high enough, you will lay off some of those employees. They had nothing to do with the crime. It has, in my view, no deterrent effect. Going to prison has deterrent effect. Telling a company that you have to pay $3 billion when the company may have made $10 billion out of its misconduct is not a deterrent at all. When using J.P. Morgan as the example, after J.P. Morgan paid a multi-billion-dollar fine, the next day its CEO got a raise because everyone considered it a good result. Yes, the companies do impose compliance measures. In my view, those compliance measures are ineffective because they're viewed by the company as imposed from without rather than coming from within. But that's not just my view. There's a whole study of this that's been done by a guy named Brandon Garrett, who's a professor at the University of Virginia Law School, who wrote a book on all this called Too Big to Jail. And he studied every deferred prosecution and every corporate prosecution from the year 2000 to the year 2014, and he found that 1/3 of them were recidivist. So it clearly wasn't having much of a deterrent effect. So without, obviously this is an area that I feel strongly about, but I think it was a great mistake not to go after high-level executives. But I'll leave it at that.
Okay. And as a final question, let's pick up on the point around the death penalty. So the U.S. and the U.K. are known to be two countries that have been very close to each other morally, politically, culturally for the last 200 years. But on one issue that they've come out very, very differently is the death penalty. And you wrote one of the boldest, most innovative opinions on the death penalty in the U.S., abolishing the death penalty, arguing it's unconstitutional.
And it took about a nanosecond before that was reversed.
Right. So walk us through that process, because presumably you anticipated that this would be reversed.
That was the hardest case I ever had, and something that I used to not talk about, but I do feel now at least comfortable talking about. So my older brother was murdered in cold blood in 1985. And if you had asked me then, did I favor the death penalty, I would have said for sure. And I think opponents of the death penalty, of which I am now one, don't always take full account of the, I think, legitimate feelings of victims. There's a tendency to write off the victims as being vengeful or racist or whatever. That may be true to some extent, but I also think that someone who's had a family member murdered feels that it is morally right that the perpetrator pay, if necessary, with his or her life. That's not the whole story. What changed my mind well into after I became a judge was the work of the Innocence Project in the United States, which showed that many people were being sentenced to the death penalty who were actually innocent, that the system was not nearly as good as we all thought it was, and that people were being put to death or put in jeopardy of being put to death who were actually innocent, and who, in effect, by being killed, would never be able to establish their innocence. So that changed my mind about the death penalty, and I became an opponent. And I thought it raised very serious due process issues in a way different from the traditional U.S. legal way of looking at this is as a matter of cruel and unusual punishment. I looked at it more in terms of a due process violation, depriving a person of ever proving their innocence, because by taking away their life, you obviously take away their ability to ever prove it. Because that was a theory that I had come up with, I felt very uncomfortable expressing it as my ruling without raising it with the parties and giving them a very, very ample time to litigate it, because I think in the adversary system, really, it's the parties that should normally control, not the judge. But I felt this, the Supreme Court has said death is different, and I felt, therefore, that I should raise this. I knew that I would likely be reversed, and not to get too personal, I knew that that would probably prevent me from advancing to a higher court for political reasons. So I raised it with my wife, who said, didn't you just tell me you're having more fun being a district judge than you've ever had in your life? So stay where you are. I did come down with that opinion. I did think it would be reversed. It was reversed. I take some solace in the belief that the Supreme Court is beginning to come around to my point of view. You guys are way ahead of us, but there is a growing group of justices of the Supreme Court who will vote for the end of the death penalty. The court as a whole is already beginning to carve away. So the court has held that you can't have the death penalty for juveniles. The court has held you can't have the death penalty for mentally retarded people. And I think it is pretty clear that they're moving towards, even the conservative justices are moving towards abolishing the death penalty, but they're not there yet, so we've got some catching up with you to do.
Fantastic. Judge Jed Rakoff, we want to thank you so much for taking the time to come here and speak to us on the judiciary as a check on executive power. We look forward to your continued engagement with the University of Oxford and the Blavatnik School in particular. Thank you.
Thank you so much.
So let me introduce you to a couple of people. This is Mohammed Mursi. He's going to join us.